management, and I've decided to talk to you as an experiment, to report to the regional offices so that they have an idea of what's going on here in the division. It's always been my policy to make information available so that the regional offices whose responsibility it is to carry out the investment company and investment advisory program on with respect to inspections and examinations could be fully informed as to why they're doing their job and, to an extent, how they're doing the job. And since you probably heard that much is going on in Washington with respect to deregulation, I thought that as an experiment that I ought to come and talk to you in person if possible, and by this videotape as an alternative, to tell you just what's going on here, just what you can expect and from us and what we expect from you. After all, to use a cliche, you are our cop on the beat. And we've always been aware of it, and I'm sure that you are aware of that. And while some of you may think that you are residing in Siberia, I want you to know that this division doesn't feel that way at all. After all, you are really our eyes and ears. You are the people who bring the problems to our attention, and we attempt, with your help, to offer some solutions. As you probably have heard, this division is in the midst of two studies, two reevaluation programs, one under the Investment Company Act and the other under the Advisors Act. Both of these programs are very important. Both of them will have a distinct impact on your work. The investment company program is a program looking to reevaluation. In effect, we are going to every section of the Act and determining whether that particular section is necessary, is appropriate in today's world. Assuming it was appropriate in 1940 or in 1970 when the statute was amended, the question comes up whether in today's world it's still appropriate. In addition, we are going into every interp that we have made under the statute to see whether it will stand up under today's standards. We are looking at our rules to determine whether they're really effective, or are they just a matter of paper, just a matter of having people file paper for the sake of filing, such as N1Rs, N1Qs. All of these things, nothing here is sacred. Now I want to say one thing, that the intent of this study is not to reduce investor protection. We have gone a long way so far in this study, and I can say that we have not changed investor protection one iota. In fact, I think we've sharpened it rather than diminished it. And we have, to an extent, as I'll explain later, done a lot of things to make our program more palatable to the industry. But at the same time, the impact, the protective impact, is still there and has not been diminished one iota. Before I became director of the division, the chairman and I had several conversations, and we exchanged several pieces of communications to determine just what my mandate would be. And it was our view that we should attempt to simplify the statute, to make it easier and yet to protect the individual investor and the institution that we call investment companies. And at the same time, not, as I said over and over again, not to detract one iota from investor protection. We came to an agreement, and what we've done is carry out what I think is the mandate that the chairman gave me. For example, in the last 6 months under the Investment Advisors Act study, which consists of 5 people, we have adopted 5 rules. The 3 unit investment startup rules. We've a Rule 10F3, new Rule 17E, and we have proposed 4 rules: 22C1, having to do with pricing, as you know, 17A6, and 17D1D6. Now, we've also, Rule 17D1D7, and we have rescinded one obsolete rule, old Rule 17E1. Now, we intend to go further. Obviously, this is a continued study, and I might mention what we're talking about when we talk about our study. Unlike the studies that we have had in the past that you are familiar with, we do not contemplate a balloon report at the end. My experience with reports at the end of a study is that most people are worried more about the language of the report than they are with respect to what the report will implement, or what will be implemented by the study. And so we have decided, as I have noted to you here, to implement the study as we go along. In other words, when we find the need to change a rule, when we find the need to change an interp, we're going to do it immediately. And we're going to get that part of the study behind us, rather than to wait and come up with a long report which everybody will have an interest in changing and fashioning to their own interests and with respect to a public image. So far, I think we've been extremely successful. What are we going to do? Where are we going? What is our real objective? Well, precisely, we're taking what I would call a world view here, a view that emphasizes programs, rather than specific exemptions. In other words, what we're doing, along with re-examining the statute, we're also re-examining each of our orders that the Commission has given with respect to exemptive applications. And we're saying, look, they follow a pattern. And following a pattern, it seems that the same conditions are in these groups of orders, this group of orders. Why not make a rule, and it saves and that the industry can follow if they want the exemption, and it saves the filing. It saves filing. It saves counsel fees for the industry, and it saves time. And as you know, time is of the essence in many deals. And many deals, as you know, that would be good for the investment companies, good for investors, have been thrown in the ash can because of the time that it takes to get something through. On the other hand, the advantage is not altogether with industry. As you know from your own from your own staff, we too have limitations in our resources, and every exemption, every application that is not filed is a relief to our personnel demands. And it would seem to me that if we can eliminate 20, 30, 40% of the applications that are normally filed in the division, we can use these resources for other things, such as what I consider very important, and by the way, what the chairman considers very important. We can use these resources for our inspection program, and bring down the cycle to what I consider the optimum 2 years. So the advantages go both ways. This is not a one-way street. And while you've heard about this so-called deregulation, I think in our case, with respect to the Investment Company Act, it's a misnomer. What I would like to say is that this is a realignment, if you will, a reevaluation, not a deregulatory program such as that which might be going on in the CAB. We are not scrapping regulations. We're modernizing them, we're streamlining them, and we're eliminating the unnecessary. Let me tell you, go into a little detail. Our exemptive rules so far have taken two directions, really. We are, on the one hand, excluding. We're looking to see where. Let me put it this way. We look to see where the potential overreaching can occur. If we find that a transaction can go on, by excluding certain affiliated persons from the transaction, those persons who really have a financial interest, who have the temptation to overreach, then we take that approach. A good example of that would be Rule 17A6. And as you know, you may have heard, under our new proposed Rule 17A6, we are eliminating the necessity to file applications with respect to downstream affiliates. I think this is a good example of our approach. As you know, in the financial world, a downstream affiliate, that is an affiliate in which the investment company owns 5%. In the financial world, with respect to industrial companies, there's no special protection given to downstream affiliates. But under a reading of Section 17A, the Commission, it would appear, that the Commission must look to determine whether or not every person has been overreached. In other words, as you know, 17B indicates that one of the issues the Commission must look to is whether there has been an overreaching with respect to any person in a deal. Now, it's only fortuitous that a company happens to have its shares owned in excess of 5% by an investment company. There appears to us to be no reason why that fortuitous event should bring any added protection to that company merely because an investment company owns 5% rather than an industrial company. Now, if Congress, in its wisdom, wants to give special protection for downstream affiliates in the total financial world, that's up to Congress. But it appears to us that the reading that we have been given over the years to protect downstream affiliates really has no basis in what I would call common sense. That merely because somebody's shares is owned by an investment company should not give that company any added protection. After all, the Investment Company Act was drafted to protect investors in investment companies and not in companies owned whose shares are owned by investment companies. Now, you may disagree with that, but I tell you about it merely to illustrate the philosophy that we're following. Now, that's one. In other words, in 17A6, we eliminate people who have a financial interest in the deal. We don't eliminate the deal, in effect. Now, there are deals, there are situations, as you know, where you cannot eliminate the affiliated persons. For example, in 17E, that section that has to do with affiliated brokers, there's just no way to eliminate the affiliated broker and have a rule. So what do we do in that type of situation? What do we do? Well, we have gone to what I call individual self-regulation. We're throwing the burden, in this particular sense, on the directors. Instead of the Commission attempting to handle the situation on a piecemeal basis, we're saying to the directors, here's the ball, fellas, you take it. You set the standards. We'll set the general standards. You set the mechanics. And in this way, you set by saying the mechanics, what I really mean is they will set the procedures to eliminate those situations which could cause an overreaching. Now, in 17E, previously, for example, we indicate the rule, old 17E1, had a provision that an affiliated broker could charge more than 1% with respect to stock exchange transactions if the commission which he did charge was customary and usual. I think those are the words. Well, after all, what is customary and usual in this age of negotiated rates? Obviously, there isn't any. If you have negotiated rates, you don't have customary and usual. So we suggested and the Commission approved a standard in which the board of directors would have to set up procedures which was aimed at paying the commissions that are being charged for the similar types of transactions at a similar time. We substituted that standard. Now, the procedures in which this will be overseen and policed will be those of the directors, will be those of the company, rather than those specific procedures that you and I have been so familiar with respect to rules now on the books under the 40 Act. In addition, we recommended, and the Commission accepted, the certain record-keeping procedures that will make it easy, relatively easy, for us to check on in inspections, and incidentally for plaintiffs, shareholders who bring suit against companies charging lack of procedures to obtain and to test as to whether or not such procedures were effective and whether they came up to the standards set by the rule. This is a completely different approach than we've ever used before. Now, there are provisions, there are things that we can't do. For example, we are wary of the fact that we're going into uncharted waters. Because of that, we don't want to go in pell-mell. There are certain things that what I call vestiges of the old rules that we still adhere to. Merely because a thing is old doesn't mean it's bad. And for example, in our 10F3 rule, the new rule under 10F3, we have said that the securities being purchased, for example, must be of investment grade, of a certain investment grade in which a national rating service has so indicated. We don't indicate what national rating service, but Standard & Poor's would be one, and you obviously have in your own mind others, so that if a security has the rating which the rule prescribed, it is eligible in effect to become to be subject to the exemptive rule 10F3. Now that is somewhat of a departure from our quote new philosophy, end of quote. But nevertheless, we felt that it was necessary because we realized that directors are not omniscient. It's a part-time job, and they do need some guidance, and we just felt that in that sort of situation, we ought to give it to them. Now, after this is all over and we've had a chance to stand back and look at what we've done and seen your reports of inspection, we might find that we've gone a little bit far, maybe too far. I, for one, will not hesitate to recommend a retraction of the rule, if you will, if we have found that we have gone too far, and that the rule is being abused, and there is, as a result of these rules, some overreaching. I don't think there will be, but I want to emphasize to you that we are not on a one-way course. We can go backwards, and we will not hesitate to do so if we find that we have gone too far. Now, what else is in the offing in the immediate future with respect to in the investment company study? Well, we're going to attempt to resolve some very nice questions. We're going into inadvertent investment companies, a subject that has always given both the division and the field headaches, to say the least. We're going into mini accounts. We're going to determine whether they're under what conditions, if any, and I emphasize if any, mini accounts can exist without registration under the Investment Company Act. We're going to attempt to resolve other long-term areas of concern. 22D. We're going to go really into 22D to determine, for example, whether a underwriter can himself, if you will, determine whether he needs price maintenance, or whether in the best interest of the fund and the distribution system, a system of varying charges depending upon conditions is appropriate, or whether, for example, there should be no limitation whatsoever with respect to price maintenance or the lack of price maintenance. Now, this may take legislation. I haven't spoken about that yet, but many of the things that we're going into may result in recommendations to the Commission that they seek legislation. But this part of the study is, I think, at least a year away. But we will determine in this, for example, with respect to 22D, what, if any, we can do administratively. Whether we can modify 22D by rules, or whether or not it will be appropriate. And I haven't reached that. In other words, what I'm trying to say is that we are not predisposed in any particular direction. We're exploring to determine whether or not it is best for each company to regulate itself with respect to this distribution process. We're going to go into senior securities, which I know has been troublesome to you, and we're going to try by rules to see if we can't define further just what is a senior security and what is not. Obviously, the subject of senior securities is not simple. It's very complex, and I would expect the study to take some time on this subject. What I want to say, and as I said before, and what I want to illustrate to you, and what I'm attempting to illustrate to you, is that nothing is sacred under this, with respect to this study. Now, you might add, you might be saying to yourself, well, it's all very interesting, Sid, but how does this affect me? I mean, why should I care what is happening in the division? Well, what is happening in the division really affects you. It's going to affect your inspection technique. You are going to have to use more of your ingenuity than you ever had before. You ever had to do before. Let's take that 17E problem, for example. You're going to, let's just take it down and see how it affects you. As I stated before, 17A is a permissive rule which will allow an affiliated person to charge those commissions which other brokers are charging for similar transactions in a comparable time period. And the rule, as I said before, is implemented by the board of directors setting up procedures. Now, you're going to have to go into, you inspectors are going to have to go into this company, look at the minutes, determine in your own mind whether these procedures are adequate. You'll have to understand what the rule is all about. The first time, you'll have to be familiar with the release which explains the rule. And this is not subject to a checklist. This takes real ingenuity. You really have to be aware of the exemptive standard, the reason for the rule. You have to look at the procedures of the board to determine whether the board was acting here in good faith or whether it just went through some Mickey Mouse procedure. Was it properly adopted? Now, obviously, these are hard judgment calls. I mean, I can't tell you, I can't give you a formula. You're going to have to use your own judgment. You're going to have to come back possibly and discuss this with people in your office. But you're going to have to make some quality determinations. As I said, this is not a checklist procedure. And as I said, you look at the procedures and you say, are they reasonably designed to satisfy the exemptive standard? Will this satisfy, will this tend to prevent overreaching? Or is just the standard that is meaningless? Did the directors monitor the compliance? What did they do? What are the procedures to monitor how transactions done by an affiliated broker are executed? What about, was this brought up in directors' meetings? Was there any reports made? Did the procedures demand that reports be made? All of these things you're going to have to look at. So inspections are going to be very, very different, it seems to me, than they had been before. Now, what are our responsibilities to you? Well, we're going to try to keep you informed. We're going to, as we always have, we're going to be here in Washington ready to answer your questions. And we're going to, and what is even more important, we're going to update inspection manuals and outlines. Now that is one part of our program. The other part of our program, and equally important, has to do with the investment advisors program. We have set up a 6-man section, branch, headed by Bob Caruso, to make interpretations under the Investment Advisors Act and to conduct a study with respect to investment advisors. Now, the investment advisors study is going to be a little different because, as you know, the investment advisors area of the Commission's program has been what I would call a stepchild. It's only been in recent years where investment advisors have managed so much money that it has dwarfed the investment company industry that the Commission has placed emphasis on that program. So, unlike the investment company program, the study program, here the impact of the study will be going a little bit further. We will be attempting here to determine what rules are necessary to implement a viable regulatory program with respect to a sleeping monster industry. We will be looking to see whether it is necessary to set the standards, to have the Commission obtain jurisdiction from the Congress to set professional standards, and whether it is necessary for the Commission to also set financial capability, financial responsibility. This is extremely controversial, as evidenced by the fact that when we went to the Congress several years ago, we were unsuccessful in obtaining such legislation. Now, in my view, we were unsuccessful because we did not have enough empirical data to show that anyone was being hurt because the investment advisor industry lacked any standards of any professional standards, or that anybody was being hurt because we did not have the capability of setting financial responsibility standards. We are looking for that data, and we are going to, obviously, the only people we can turn to for that data is you. The industry would not accept under some type of investigation, would, in my view, not be a ready source of such information except through the inspection process. Therefore, we are going to be looking to you for such data. We are also going to get some of that data from the new brochure rule and the new ADV. But in the main, we are going to be looking to the inspection program of the Commission to get the necessary information, if you will, the blood on the floor evidence, to allow us to go to Congress, if appropriate, to request such information, so that when you have enforcement cases or you have inspections which show that violations have occurred because the investment advisor or his employees were not capable to give investment advice, either because they had no experience, or they had no training, or they had none of that either, or none of both. It seems that it's only in this way. Now, we're also in this area exploring a different tact. we are exploring the possibility of having self-regulatory organizations set the standards. In this way, we will avoid the accusation that Big Brother, that knows very little about the investment advisory business, will take upon itself the task of setting standards. Now, as you know, unlike the brokerage industry, investment advisors have no financial incentive to join a self-regulatory organization. Under the NASD, as you know, there is a financial advantage. There are certain advantages. As a practical matter, a non-member of the NASD cannot go into any underwriting except as a member of the public, getting no additional concessions. No concessions that a member of the public wouldn't get. He can't sell, as a practical matter, he can sell mutual fund shares because there are no member underwriter would give him any concession. So he would have to buy at the public offering price. But that isn't true with investment advisors, because investment advisors do not have interrelations with each other. So we are exploring the idea of having what we call the integrated bar concept. We are attempting to see if it's feasible to force investment advisors, before they can practice investment advice, if you will, if that's a proper expression, to force them to join a self-regulatory organization. Now, this self-regulatory organization would not necessarily be one organization. There could be many organizations, but they would be overseen by the commission. Their rules would be subject to commission review. And in our concept, which is in its infant stage, if any self-regulatory organization barred a person or expelled a person for moral turpitude, for example, that person would not be able to join another organization until he had satisfied the commission, for example, that he was capable, and that so that we would have, in effect, something akin to the NASD procedures, but at the same time different. This procedure, when I said the integrated bar procedure, for example, in the District of Columbia, a person cannot practice law, even though he's a member of the bar, unless that person is a member of the DC Bar Association. And that's why I said, and they call this the integrated bar system. So I'm coming to you now to just give you an idea, as I said, of what we're doing. Now, let me go back and say this, that we welcome each of your suggestions. We are not omniscient. We don't know everything. And there are many problems out in the field that we are unaware of. And when we do hear of them, we hear them usually at a stage that is difficult to cope with. So I would suggest that if you have any changes that you could suggest, with respect to the Investment Company Act or the Investment Advisors Act, call us up, or send a memo in. We would really appreciate it. We want you to work with us. We are attempting to work with you. If you think that what I've said here is worthwhile, we'll repeat it. I'll attempt to repeat this periodically. If not, one shot was enough. Therefore, I would like you to drop us a line to determine, telling us whether you thought my little talk was worthwhile. Thank you very much.